Good morning and welcome to the liquor licensing panel meeting, which is being held today, Tuesday, the 23rd of January. Welcome. So I'm going to move straight on to the agenda. Item 1, to receive apologies for absence. I have none. So item 2, to receive declarations of interest from members in respect of any matter on the agenda. Do I have any?
No.
Wonderful, we'll move on. The procedure of the licensing panel will follow in considering the application is set out in the Licensing Act 2003, its attendant regulations, and was agreed by the Licensing Committee on the 2nd of February 2005. The licensing panel, in accordance with Rule 14 of the Licensing Act 2003, Hearings, Regulations 2005, decide to exclude the public from all or part of the hearing where the licensing panel considers that this is in the public interest to do so. So, item 3 on the agenda, to be agreed by general affirmation the minutes of the previous meetings held on the 8th of November 2023.
Hi, I'm Alex Walker, legal advisor to the panel. These minutes will need to be deferred to the next committee.
I thank you.
Sorry, Alex, that's sorted.
Item 4. We now move on to the substantive, which is the application to vary a premises Licensing Act 2003. I would like to invite John Bryant, our Senior Licensing Officer, to do the introduction and outline. Oh, yes, sorry. No? Oh, yeah. I'd like to ask Alex, the solicitor, to advise us on the new guidance which we have.
I'd just like to say that I've given advice to the panel that there is new section 182 of the Licensing Act 2003 guidance, which was published on the 18th of January 2024. I've provided advice to the panel that this guidance doesn't apply retrospectively and that they will be considering today's application under the guidance which was in place at the time the application was made.
Thank you, Alex. So now I would like to move on to John Bryant, Senior Licensing Officer, for an introduction and outline of the report.
Chair, thank you. Members, the matter before yourselves today is to determine an application to vary a premises licence. In summary, an application pursuant to Section 34 of the Licensing Act 2003 has been made by Mr Thornton on behalf of Mr Hancock, who is the holder of the premises licence at the Cricketers Public House, which is situated at 23 West Street, Burgess Hill. Representations against the application have been made by 5 interested parties on the grounds of the prevention of a public nuisance. Now, the substance of the variation application is to extend the times for the sale of alcohol by retail and the provision of late night refreshment, amend the opening hours, and to remove outdated licence conditions and update and add new licence conditions. And therefore, the panel is asked to determine the application in accordance with the Licensing Act 2003, the Mid Sussex District Council licensing policy, and the Home Office guidance, which has been issued under Section 182 of the Licensing Act, whilst having due regard to the applicant's submissions and the relevant representations that have been made. Background to the application is the Cricketers is situated in West Street. It's at the junction with Fairfield Road, Burgess Hill, and Mr Hancock is the holder of the premises licence. It's held a premises licence since the introduction of the current Licensing Act, and previously under the earlier Act, the Licensing Act of 1964. In the report, I've set out the current licensable activities, which the members will see, and the various non-standard timings which are on the current licence and the opening hours. There are also a number of conditions which are attached to the licence in addition to the mandatory conditions. These are set out in the report. And part of the variation is to update these conditions as they are, by modern standards, rather outdated and outmoded. So the variation seeks to increase the hours for sale of alcohol and late night refreshment on 3 nights of the week, which is Thursday, Friday and Saturday, from midnight to 1 a.m, to amend the current opening hours accordingly and to, as I said, to update and amend the current conditions. The details of the variation are set out in the report at paragraph 10. And representations have been received from 5 members of the public, which are referred to as interested parties within the Act. These representations have all been made in respect of the licensing objectives of the prevention of a public nuisance. I would point out there are no representations from any responsible authority. The concerns have been resolved by minor amendments to the proposed new conditions and the agreement with an additional condition with the Environmental Protection Team. If the panel decides to grant the variation, either in full or part, I would request that in addition to any other conditions felt necessary and proportionate by the panel, the amended and additional conditions proposed by the applicant and agreed by the 2 responsible authorities be attached to the varied licence. Full details of these conditions are attached in the appendix, which I shall go through at the end of this presentation. The application was correctly advertised at the site between the 29th of November 2023 and the 26th of December, and also published in the local newspaper on the 7th of December. Now we're turning to the interested party representations. There's one from Lucy Chapman. She states, the noise levels are already bad, especially during summer months. I have concerns about people parking their cars in our close, which is already an issue as there isn't sufficient parking on site, then driving home at 1:30 causing a disturbance. Devon Busby Kelly has made representations on the grounds of prevention of public nuisance. They state, I feel very concerned about this due to the potential of noise leaving the pub later than they already do. This is mostly due to the fact that people are unable to mostly park in the car park of the pub due to the 2 parking spots not being able to be used for cars. The front car park is completely full of old cars and the back mostly full of cut down logs. I'm assuming this is other business running in the pub's location. This means that people who visit the pub don't park there as there is only about 8 spaces, which some are of course taken up by staff. Instead, people park on main roads and closest that's the nearest. Especially during the summer, you always get woken up by cars leaving the pub or drunken people leaving. At least at the moment it's only midnight, but the idea that it's going to be later is worrying. The pub is not in a town centre or a location with no one around. It's surrounded by residential properties, including flats, houses and old people's home. Also, though I appreciate the pub saying it will lower noise and not allow people outside, but people will be going in and out as they do now to smoke or talk, and they will be heard as you cannot control how loud they're going to be. And when they do open the doors, especially when in very hot weather, people will want to go outside to cool down, and we will hear the music as we do now. I have nothing against the pub, but I know so many of my neighbours and others that live close are very concerned over this change. If something could be done about the car park so people who are visiting do not park by people's houses, it would certainly ease the worry, but as it stands, we already have enough trouble with people leaving and making noise at midnight. Please do not make this any later. Debbie Busby makes representations which are similar, stating, firstly, I have nothing against the pub. At one time, my granddad used to serve there. The problem is not in the town or in the country. It is in a residential area. The noise aspect worries me as you cannot stop people shouting, laughing. They have had a good time, but unfortunately, they park in the roads where we live. In the summer, our windows are open, so we will be woken up in the early hours of the morning. Unfortunately, there are no other place to park except outside our houses or even by our garages. Linda Steer makes a similar representation on the same grounds. I cannot see the need to be open later. The noise level when people leave is unacceptable, especially in the summer when windows are open. We already have to put up with their customers parking outside our houses and leaving at different times of the day and night. And Jane Davey makes a representation on the same grounds, stating, with reference to the above and with regard to increased licensing on Thursday, Friday, Saturday, we have had numerous complaints over the years where I've been in touch with the licensing department due to noise and drinking outside every weekend. People are drinking outside well after 2300 hours, even up to around 12:30 a.m. and outside in garden and front of the pub quite often. When I'm a late shift, I get dropped off in my taxi and people outside shouting and drinking well after midnight. As well as music, which can be so loud you have to close the windows. If only the landlady would adhere to the rules, and customers, I wouldn't be sending this email. With reference to the above, I can confirm that the comments I've made are on the grounds of potential public nuisance. The extended hours will have a detrimental impact in this matter. We have endured quite a lot of noise and nuisance over the years. The only time we have any respite was during the pandemic. I believe the extended hours would only make matters worse. Those are the full representations made by the interested parties. I will point out that the panel will note that comments surrounding parking issues in the locality could not be considered as being relevant in respect of the application. And the consideration of the panel is in respect of the effect of the likely effect of the variation on the licensing objectives, and it's not a process to review the current licence. The determination of the application, the panel must determine the application as stated in accordance with the Licensing Act, the Mid-Sussex District Council licensing policy, the Home Office guidance issued under section 182, whilst having due regard to the applicant's submissions and relevant representations. I've set out in the report the legislation, section 34 and section 35 of the Act, which details the requirements of the panel in decision making. And needless to say, if you have any questions regarding that, then they would be directed to your legal advisor. Moving on, the Licensing Act requires that representations address the 4 licensing objectives, which are the prevention of crime and disorder, the prevention of a public nuisance, promotion of public safety, and the prevention of harm to children and young persons. And a representation is considered a relevant representation if it is about the likely effect of the grant of the licence on the promotion of the licensing objectives. The objector must establish that such a consequence is a likely effect of the grant, i.e. more probable than not. There is guidance issued under section 182 of the Licensing Act, which I know the panel will be well aware of, but just to highlight various parts of the guidance for the panel. It deals with public nuisance at 2.21, and it states that the Act enables licensing authorities and responsible authorities through representations to consider what constitutes public nuisance and what's appropriate to prevent it in terms of conditions attached to specific premises licences. It's therefore important in considering the promotion of this licensing objective that licensing authorities and responsible authorities focus on the effect of the licensable activities at the specific premises on persons living and working in the area around the premises, which may be disproportionate and unreasonable. The issues will mainly concern noise, nuisance, light pollution, noxious smells and litter. And it goes on to say that beyond the immediate area surrounding the premises, these are matters for the personal responsibility of the individuals under the law. An individual who engages in antisocial behaviour is accountable in their own right. However, it would be perfectly reasonable for a licensing authority to impose a condition following representations that requires a licence holder to place signs at the exit encouraging patrons to be quiet until they leave the area, or if they smoke, to do so at designated places, and to respect the rights of people living nearby to a peaceful night. When a representation concerning licensing objectives is made by a responsible authority, the licensing authority's discretion will be engaged. It's also engaged if another person, an interested party, makes relevant representations, which are not frivolous or vexatious. And representations can be made in opposition to or in support of an application. A representation is relevant if it relates to the likely effect of the grant and the licence on the promotion of the licensing objectives. And the guidance then sets out what would be examples of what would be regarded as relevant and which would be regarded as irrelevant. But it does state that for representations in relation to variations to be relevant, they should be confined to the subject matter of the variation. It is for the licensing authority to determine whether representation is frivolous or vexatious on the basis of what might ordinarily be considered as vexatious or frivolous. And the guidance sets out what grounds you would consider representations to be either vexatious or frivolous. But it does say that in borderline cases, the benefit of the doubt about any aspect of a representation should be given to the person making the representation, and the subsequent hearing will be an opportunity of the person or body making a representation to amplify or clarify it. Obviously, each responsible authority is an expert in their respective field, and in some cases that it will be the particular responsible authority that would be the licensing authority's main source of advice in relation to the particular licensing objective. For example, the Environmental Protection Team have a key role in preventing a public nuisance. As a matter of practice, licensing authorities should seek to focus the hearing on the steps considered appropriate to promote the particular licensing objective or objectives that are given rise to the specific representation, and avoid straying into undisputed areas. A responsible authority or person may choose to rely on a written representation, which the four interested parties have done in this case. Licensing authorities are best placed to determine what actions are appropriate for the promotion of the licensing objectives in their area. All licensing determinations should be considered on a case-by-case basis. They should take into account any representations or objections that have been received from responsible authorities or other persons, and the representations made by the applicant or premises user, as the case may be. And the authority's determination should be evidence-based, justified as being appropriate for the promotion of the licensing objectives and proportionate to what it is intended to achieve. The report then sets out sections of the Mid-Sussex District Council Statement of Licensing Policy in addition to other parts of the statutory guidance, and obviously details that the financial implications are that the final decision made by the panel in this matter is subject to an appeal in the Magistrates' Court by any party to the proceedings. To take the panel through the appendices, Appendices 1 is the application form, detailing the application. Appendix 2 is the current premises licence and the premises licence plan, which is attached to the licence. Appendix 3, the panel may find more helpful as well. You'll see there is initially a map of the area which highlights the cricketers in the centre of the map, showing it's at the junction of Fairfield Road and West Street. The interested parties who've made the representations come from the area of Fairfield Close, which is to the south of the pub, and also Soames Court, to obviously give the panel some context as to where they are. The following parts of the appendix are photos of the location. First one's being photos of the premises from the junction of West Street and Fairfield Road, looking towards the pub. You then have photos of the side of the pub down West Street. Further along, photos of the pub looking from West Street down Fairfield Road. And Fairfield Close is down on the left-hand side. And then the final pictures are from the direction of Soames Court and Fairfield Close towards the pub. Appendix 4 are the proposed and agreed conditions, which I would ask that the panel consider replacing all the current conditions with. As stated, these have been agreed with the responsible authorities, the police and the Environmental Protection Team. And finally, Appendix 5. You recall during the report I mentioned that the Environmental Protection Team specifically have responsibility surrounding the prevention of public nuisance. You'll find the full comments from the Environmental Protection Team in respect of this application, details of the agreed condition with the applicant, but it may also assist the panel in giving some context to the reasoning behind the Environmental Protection Team's response to this application. That's the application before the panel, and obviously I'm available to answer any questions you may have in respect of the report.
Any questions, Mr. Bryant? Would you have any questions?
I have no questions, Chair.
Thank you. Right, I think we're quite happy, thank you. I'd like to invite the interested parties to direct questions. You didn't have any, we didn't have any, so I should like to ask you to make your representation.
Thank you, Chair. Good morning, and members of the committee, good morning, and good morning to everybody present. My name is Paul Thornton, and I'm a licensing agent acting on behalf of the Mr. Hancock, the applicant. One should never start off with an apology, but I'm going to have to this morning. Apologies for Mr. Hancock's absence this morning. As well as being the leaseholder of this pub, he's also he has a licensing consultancy business, and he's been called away to an important meeting, for which I can tell you he does regret not being here, but I thought I would let you know why he's not here. The DPS for the site, Sharon Wilson, is with me this morning, and although she won't be addressing you, she is available should there be any questions that you or anyone else may have. Chair, on to the application. This seeks an extra 3 hours a week to add to the current 91 hours, and the 3 hours are spread over Thursday, Friday and Saturday evenings, basically from midnight to 1 a.m. The proposed terminal hour is for the licensable activity for the sale of alcohol and late-night refreshment only. There's no application to extend permission for regulated entertainment, i.e. music, dancing, etc. That is going to remain the same as it is now at 23:30 hours. The simple reason for the application is to retain customers at the site beyond 23:15. And that reason is that there are 3 pubs within walking distance, a 10-minute walk of this pub, which is the Woolpack, the Windmill and the Brewers Arms, that can serve alcohol until 1 a.m. Now, I'm as mindful as you are that all sites must be treated on their merits, and that there are no blanket hours. But this anomaly means that regular customers who would normally stay later at the Cricketers are leaving on these nights, Thursday, Fridays and Saturdays, to get a late drink elsewhere. And quite simply, their management are looking to retain those customers. You will be acutely aware of the damage done to the hospitality industry during the COVID pandemic. And I can assure you that that damage is still being felt as businesses struggle to regain their previous trading levels. If this application is successful, and it is only for 3 nights a week, it will ensure that customers will not be lost to other establishments locally. Your licensing policy referred to by Mr. Bryant, paragraph 23 of this report, requires measures to be demonstrated as to how the licensing objectives will be promoted in relation to the application for later hours. You will note that the current premises licence, which we think was originally drafted around 2005-2006, contains some archaic and quite frankly unworkable conditions. Our application proposes to delete these conditions and add those which are comprehensive and capable of being enforced and are fit for purpose in the 21st century. They include a detailed CCTV condition stating where cameras should be placed, a requirement by the management of the pub for up-to-date training and for records to be kept. In addition, there's a cut-off time for the use of the outside garden and patio area for 2200 hours, no outside drinking after 2300 hours, and a last entry time of 23:30 hours to new customers. Now, although these conditions are proposed in support of the current application for the additional hours on Thursday, Friday and Saturday, they will all apply during the rest of the week when the terminal hour is midnight. So I believe we have adequately fulfilled the application and in the application the requirements of your licensing policy at section 9, paragraph 5. Now you will note that Sussex Police has raised no objection to the application and have accepted the proposed conditions in full with no additional ones required. Your environmental health officer has produced a very detailed report, but has not objected at all to this application. And you will note that from Sussex Police, there are no untoward incidents reported regarding the pub. The pub itself, members of the committee, and this is according to your Burgess Hill Museum, was established in the mid-1850s. And according to the museum, was probably named after the game of cricket played in the adjacent field, which is now a recreation ground. It is now, unlike then, in the midst of residential housing, of which the managers are acutely aware. So whilst addressing the concerns of those making representations, I am mindful of being respectful towards them, yet I'm also minded about being able to defend our application and to push back at some of the comments. Mr. Bryant has already outlined the position regarding parking, and whilst it's not a matter for your committee, it's worth noting how Mr. Hancock intends to address the issue of the rear car park. There are a number of cut logs in the car park, and it reduces the available spaces by one. I've had a look at it this morning. Now, Mr. Hancock cuts these logs himself and uses them on a very nice open fire in his pub. And the rest of it he sends to local pubs for use on their open fires. He has moved the logs to the bottom of the car park, and thus there is made more space available for cars. So there are, when I counted this morning, there are 8 spaces available in that back car park. He would, however, like it noted that probably 90 to 95% of his trade is a walk up to the site, and in keeping with it being very much a locals pub. He's not saying that people don't drive there, but in the main, it is a walk up. However, notwithstanding the issue of traffic, it is a residential area and some busy roads, and there are lots and lots of cars about in any event. Locally, there are 2 football pitches, one used during the midweek and the other's on a Saturday afternoon, and on these days the area is absolutely teeming with cars, footballers and people coming to watch the games, fighting for spaces anywhere they can park their cars. I would like to return now to address the noise issues which have been made by those making representations. Mr. Bennett, your Environmental Health Officer, notes 2 complaints about noise. One is from the garden area in 2018, and the other one is from the car park in 2020. Neither of these resulted in any formal action and were, in his words, informally resolved with the managers. Now, various comments have been made relating to drinking, and I quote, drinking outside every weekend well after 2300 hours, even until midnight in the garden, and at the front of the pub with music so loud you have to close the windows, end of inverted commas. Others talk about unacceptable noise levels from customers, especially in the summer. And so I will repeat my earlier comment, members. I wish in no way to diminish the comments or concerns of the residents, but I cannot see a correlation with the behaviour as described and the complete lack of any involvement by the council or police in relation to any complaints about the site. I have no doubt that a pub in such a location will from time to time be guilty of some noise escape, either by a door being left open for too long, or a customer being, to use one of Mr. Bennett's phrases, a little too exuberant. However, I would stress that neither Mr. Hancock nor Miss Wilson, the DPS, recognise these comments, that this is an occurrence every weekend of the year, as has been suggested. Now, the pub does have a website, and its phone number is very easily accessible, and Both of them welcome information from local residents if noise levels are becoming intrusive. The age-old line that if you hear nothing to the detriment of your business, then everything must be okay, I think is pertinent in this case. So the line there is that if local residents do feel or are aware of noise, which they might not be aware of whilst they're running the pub, then a phone call, they would rather have a phone call to the pub to deal with it there and then, and that's probably better than having the environmental health or the licensing officer making an inquiry 3 or 4 days later when the actual chance to nip that problem in the bud has gone. You will note in the new conditions that we propose the garden patio area will be closed at 10 p.m, 2200 hours, and that there will be no drinking outside after 2300 hours. Mr Hancock and Miss Wilson are acutely aware of their responsibilities, given the location of the pub, and are vigilant to problems, such as people being noisy or doors being left open for too long. And they are very anxious to address them. They have, after all, got a business to run. It's worth addressing Mr Hancock and Miss Wilson's involvement at this site. Mr Hancock's got over 40 years' experience in the licensing trade, having run several pubs both in Burgess Hill and the wider Sussex area. He did at one time run a nightclub in the centre of Burgess Hill that had a licence until 3:30 a.m. So, and in addition, as a personal licence holder and leaseholder at this site for nearly 14 years, he's also, as I alluded to earlier, has a licensing consultancy business which offers advice and guidance to individuals and businesses about the trade. He is highly regarded within the licensing trade. Chair, I do have a reference from the freehold company, which is Stonegate. If I could be permitted to pass that to members, just for your.
Yeah. Excellent. Thank you.
Thank you, Chair. Sharon Wilson, the DPS, has been a personal licence holder for over 15 years, and she's been at this site, minus a few months, for nearly 14 years. They're very experienced operators, and certainly amongst, I would suggest, the longest serving licensees in your district. They know their customers, and vice versa. And this enables them to maintain a code of conduct with their customers regarding noise, behaviour and discipline. It's also worth noting that the pub's recently undergone a refurbishment, and there are plans actually to refurbish the outside, but the interiors had an extensive refurbishment, and Ms Wilson tells me that they have a noticeable change in the demographics of their customers, and so the pub is, or the business is evolving as a result of that investment by them. So in conclusion, Chair and members, this is a well-run pub, evidenced by the longevity of service, Mr Hancock and Miss Wilson, and the lack of incidents and complaints to Sussex Police and your environmental health team and your licensing officer. You will note that neither responsible authority has raised objections to this application. And you will note that the updated and comprehensive conditions in support of this application, which is for an extra 3 hours a week on top of the existing 91 already available for licensing activities. It's worth noting that last December, just gone, the site opened at 1 a.m. At weekends, or until 1 a.m., not at 1 a.m., until 1 a.m., under the authority of temporary event notices on 16 different occasions. And I'm not aware, and I've not been made aware, and nor have either Ms Wilson or Mr Hancock, not been made aware of any complaints received during this time. Members, it's my contention that you are able to grant this application, safe in the knowledge that all the factors I've mentioned today will ensure the licensing objectives are properly promoted. I commend the application to you, and thank you for your time.
Thank you very much, Mr Thornton. Do you have any questions?
No, Chair, no questions.
Thank you. Do we have any questions, team?
One question.
Right.
Say you want to offer last entry at 23:30, how will you enforce this?
That would be simply a matter of the DPS or the staff being aware that nobody can come in as new customers. So if somebody goes out to smoke, they can come back in. But it would be simply a matter of if a new customer comes in after 11:30 at night, they would just be refused entry and refused service.
Thank you. Any other questions, team?
Yes, I was just wondering, the outside area, you said will be closed for orders, 10 o'clock. Will that be, I mean, presumably people can still hang around out there if they just ordered a drink 10 minutes before. Will that be supervised out there in case people do hang on for longer and create a noise?
Indeed, sir. My instructions are that the staff actually physically go out and clear the area at that time, and actually tell people to bring their drinks in, and actually don't let people out there. They police that quite strictly.
Thank you. Thank you. That's lovely. We have no interested parties here to ask questions or offer representations. So I'd like to invite yourself. You've summed up. We've done all that, haven't we? So make sure there's no further questions from us. We've done that, haven't we? Lovely. So, over to you.
Thank you. The panel will now retire to consider all the representations made. The panel may make their decision today and communicate that verbally with written confirmation of the decision, reasons and details of how to appeal to be provided within 5 working days. So we'll retire now and reconvene shortly so that the panel can let you know how they're proceeding with the application.
Thank you for waiting. The panel is in agreement, having considered all the information. That information being the Mid Sussex District Council licensing policy, the government guidance, the representations which have been put forward, although no formal complaints have been received in the recent past, and the reference from the Stonegate Pub Group. And we all agree to extending the times, removing the outdated conditions and replacing with the 10 proposed and agreed licensing conditions. We would like to remind the applicants that should regular noise complaints be received following these amendments, this could lead to a review. But that's our decision. Thank you.
Just to say that the applicant or any person who's made a relevant representation has the right to appeal against the licensing authority's decision. Any appeal must be made to the Magistrates' Court. This area is covered by Brighton Magistrates' Court, and any appeal has to be lodged within 21 days of being provided with written notification of this decision. This information about the right to appeal will be provided as part of the written decision you will receive, which will be provided within the next 5 working days.
Thank you. So I'll close this meeting at what? 10 past 11. Thank you.